Okay, so from a divorce perspective, here we have the couple, Vishal and Jenny, divorcing in California, and basis on which California court would exercise divorce jurisdiction, and would a California court seek to redistribute property, including community property, and how would they enforce a pre and post-nuptial agreement if that was actually agreed in California? So again, Ivan, I'd invite you just to run us through briefly these factors.
Sure. So California's basis on which to exercise divorce jurisdiction is more so of a factor test. There's a few factors. Number one is first in time, whether or not this is the first court in which the couple tries to proceed with a divorce. The second one is primary residence, whether or not the couple's primary residence is based in California or another state. And the third one is location of assets. So suppose one spouse tries to get divorced in California, the other party could argue the California courts that the California court is an improper venue and thereby try to change the venue. And the California court would then look at all right, are we the first in time? Is this the primary residence in California? And are the assets in California?
And
whether or not, sorry.
Just on the community point, would they actually, when exercising the divorce court powers, could they try and redistribute even community property?
They would. They definitely would. So I think that the tricky thing is community property is already owned 50-50. So if any property that you obtain that's community property, even if it's titled to one person, for example, with let's say a primary residence in California, let's say it's titled to the wife's name, but because it's community property, upon a divorce proceeding, the court would say, look, that's 50-50, 50% the husband's, 50% the spouse, the wife's, in which case California court a lot of times will either force one party to buy the other 50% or force the sale of the property and then split the proceeds 50-50.
Okay. And then the nuptial arrangements, I guess it's all down to what you said before.
Mm-hmm. Yeah, validity.
But if they are valid, then the court should follow what the nuptial agreement said. Is that right?
Absolutely. Right. That's right.
Okay, I think it's a fairly simple question from Diana. This is the whole thing around the DIFC trust. From Ivan, from your perspective, California can do extraterritorial orders under a divorce proceeding. They're capable of doing that? Yeah. Okay, so we could have a situation where a DIFC trust is being challenged by a court order from the US. And I think, Diana, it's pretty much as we mentioned before.
Exactly.
Yeah,
it's the community property that would prevail here. And
right, but
yes,
the order that wouldn't, yeah, because the trust protections are so strong on DIFC trusts that they wouldn't recognize a foreign court order trying to exercise a discretion here.
Unless that is the situation. Now, I have to say that onshore, now, I think prenups will be the happening thing because of the fact that we are gonna eventually go with the law of the marriage. We will have the prenups being, the norm, which has never been before. So we're just waiting for the new thing of having prenups done, yes, extensively.
I think you're going to be very busy, Diana.
It seems so.
Okay, so Shreya, from your perspective, here we have a court order emanating from the US, from a Californian court. And the question that we're going to ask is, will an Indian court recognize and enforce the terms of that, given the array of assets that are held, an interest in a trust, an account in India, land in India? If a Californian court tried to sort of change the legal ownership of any of this, how would it be received by an Indian court?
So it could be considered conclusive, Zach, although there are some exceptions where this may not be the case. One is where the jurisdiction of the foreign court is challenged, or where the divorce decree is considered to have been given in a manner that's opposed to natural justice, or in a manner that's fraudulent, for instance, or if it results in a breach of any law that the Indian court thinks should be applicable in India. So one common situation that that you may want to keep in mind is that a lot of non-resident Indians, even when they are permanently resident outside India, they frequently come back to India to get married. And so they may actually be registered under an Indian legislation, like the Hindu Marriage Act or Foreign Marriage Act, for instance. And in that case, you need to evaluate whether the condition for divorce under Indian law is different from the condition applicable under the relevant foreign law. So, for example, bigamous marriages under Hindu law are voidable at the option of the wife in India. They're not considered to be void immediately. So if there's a conflict in the foreign jurisdiction with a concept like that, for instance, then there could be a situation where the court would say that the two laws applicable are essentially in conflict, and therefore we will not enforce this foreign judgment. But barring situations like that, it should generally be possible for foreign divorce decrees to be enforced in India.
Right, okay. So far as the UK side, it comes back to what I said earlier, where we have an order trying to sever property, that generally won't be recognized. But if it's liquidated damages or a money amount, then the reciprocal should kick in. But in this instance, if they're trying to split UK property, then this won't be something that the UK courts would